Good afternoon, everybody. Thank you for joining us today on this beautiful Tuesday, I guess. I'm Howard Perl, shareholder with Becker. I'm here with my partner, Lilliana Farinas-Sabogal, also a partner in Becker. And we're here to talk about the who, what, when, and where of covenant enforcement. So I'm sure this is a subject that's near and dear to everybody's heart. And believe it or not, as simple as this can be sometimes, it seems to get very easily mixed up or not done properly, which can inhibit an association's ability to move forward with enforcement. So hopefully today we'll be able to give you some insight and some basic details as to how to preclude that and how to go through your covenant enforcement in a proper manner so that if further action is needed, the association can move forward with that. And with that, I'm going to turn it over to Lilliana to get us started with talking about what is a violation. Lilliana?
Thanks, Howard. Good morning to everyone that's joined us. Thank you so much for taking the time to learn about this very important subject. Aside from assessment issues and maintenance issues, violations, I would bet, is our number one question as attorneys. What to do about them, when the board can take action, what kind of action they can take, and what kinds of things can they take action against. So what is a violation is a really important question because unfortunately, sometimes boards tend to assume that they can stop someone from doing something, but they miss the integral step of making sure that it is already a rule or some covenant that's in their governing documents. So, for example, the association's governing documents is your declaration of condominium or declaration of covenants, if you're an HOA, your bylaws, or your rules and regulations. If you don't have a provision prohibiting something in any one of these documents, then if a person does something and you don't like it, it can't be a violation because there's no restriction against it. So the first step that everyone needs to take when looking at a situation that's become bothersome or that someone has complained about is, do we have a restriction? And if we have a restriction, has then there been a breach of that restriction? Has there been a violation? So number one step is double check your governing documents. Make sure that they have what restrictions you normally see or that you would like to have enforced in your community before you take the next step to ask, has anyone violated this? So what happens if they've double checked, yes, there is a restriction, and yes, this person has violated the restriction? What do? What's the first step?
Well, let me ask you a question before we move on, Lilliana. Can the board change or add to the rules and regulations of a community?
Well, that's a great question. Thanks for asking that, Howard. Yes, absolutely. Let's talk about the types of documents. I guess let's take one step back. You've got declaration and bylaws, which 9 out of 10 times requires the vote of the owners to change. So if it's not in your declaration and if it's not in your bylaws and you want to add something there, you're probably going to have a meeting of the owners, propose amendments, and get it in that way. The other type of restriction that you have is a rule, regulation, or restriction that is board made. Now you need to check your documents because some documents require unit owners as well as board to approve rules and regulations. But most of the times, the board is allowed to make rules and regulations at a board vote alone, as long as it's not something that's conflicting with the declaration or the bylaws. So if you have, for example, pool hours, you can restrict the hours that people are going into the pool, gym hours, 100,000 things that you can do by rule or regulation. And those things typically can be added to or amended by the board of directors. Again, double checking your documents or asking your association attorney to make sure that rules and regulations are modified by the board alone and don't require either a unit owner approval or that they don't have a unit owner veto possibility, which also exists in some older documents where the board has the right to enact rules and regulations, but the unit owners by a certain percentage can veto those regulations. So if you have an issue in your building and it's not something that is covered in your declaration and it is the type of thing that can be regulated by rule, then the board can meet and can add rules and regulations. Yes.
And obviously those rules and regulations have to be approved by the board at a duly noticed meeting where the item is on the agenda.
Always everything that we talk about here must be done in the Sunshine State. So you need board meetings, need to be properly noticed. And actually, if we have a little bit of time here, I'm just going to take a beat to talk about the type of notice, because you have two different kinds of rules, and those kinds of rules can affect the type of notice that boards need to give for the meetings. So ordinary board meetings, typically speaking, 48 hours posted on the condominium or community property for a regular board meeting. Most rules are going to fall into the typical board meeting rule requirement, notice requirement. But if the board is authorized to enact rules and regulations that affect unit or parcel use, then that kind of a rule can only be adopted at a meeting that the board has given notice 14 days in advance, mailed to the unit owners, just like a budget meeting or a membership meeting. Even if it's a board vote, those types of unit rules and parcel use rules, they need special notice. So yes, everything that a board does here, or a committee for that matter, needs to be done at a properly noticed meeting. Just depends on the kinds of rules that they're modifying or enacting to determine what kind of notice they need.
And one last comment on that is, we always suggest when the board's considering adopting or amending the rules, check with your association attorney before you go through the process of approving that rule, just so the attorney can check to make sure, one, that rule is something the board has the authority to enact, and two, that it's not in violation of any other provision of the declaration or the bylaws or anything like that.
Yep.
So, all right, so let's say we have a violation. We know we have a violation. What's the association's next step? Well, the next step is for the association to send a violation letter. So what do we want to do in regard to violation letters? Well, the first thing is the association should have a written policy regarding violation letters. In other words, you don't want to reinvent the wheel every time a new violation letter has to be sent. And you give a 5-day notice this time, and you give a 10-day notice the next time. So the association should have a written policy regarding violation letters, when they're sent, what the deadlines are there any fines involved, and we'll talk about fines later, when to send the violation to the attorney if further follow-up is needed. So based on that written policy, the first violation letter would be sent. Generally, the manager can send that violation letter, the first violation letter, generally, typically, can and is sent by the manager. Depending on the violation, depending on the association, the attorney can send that letter as well if it's something serious, or something that maybe needs the attorney's attention right away. But I would say generally that can be sent by the manager. You want to make sure the violation letter is sent to the right party. All right. So if you just have an owner, the violation letter is going to go to the owner. The association should send the letter to the address it has on file for the owner in the association official records. As a backup, I always recommend that you check the property appraiser's office and see if there is a different address for that owner. And if there is, send a copy of that letter to that address on the property appraiser's website. There is no requirement that these violation letters be sent via certified mail. There's certainly nothing wrong with doing so, okay, but it's not a requirement. If there is a tenant in the unit, and if the tenant is the one causing the violation, the letter should still be addressed to the owner, advising the owner that their tenant is in violation, and then obviously you're going to copy the tenant. Some associations like to send the letter to the tenant and copy the owner. I don't think it really makes a difference one way or the other. From a legal perspective, I always like to send the letter to the owner and then copy the tenant. What do you prefer, Lilliana?
I actually prefer to the Senate, sending it directly to the tenant with a copy to the owner. Because if the violating party is the tenant, I want them to know you are in violation, and we're letting the owner know as well.
And again, like I said, I think either way is appropriate. The key is you need to send it to both. That's the key takeaway from that provision.
Why, Howard? Why should we send it to both?
Well, if we need to go to further enforcement action, like we're going to talk about later, let's say for argument's sake, you're going to file a petition for arbitration and you've never sent the violation letter to the owner, you've only sent it to the tenant, then that'll get kicked out of arbitration for lack of proper notice. And we'll get into that in more detail later. So I always recommend that you refer to the specific provision of the governing documents that's being violated. Section 10.2 of the declaration says you can't park here, you parked here, you're in violation. All right. State specifically what must be corrected. Don't just say you're in violation, say move your car. Okay. Or don't just say you can't have a Christmas ornament on your front door in July, remove it. All right. You need to tell them what you want to be done. You need to give a deadline for compliance. All right, don't leave it open-ended. Don't just say, please remove the wreath from the door. All right, because, 3 weeks later, oh, well, yeah, we'll get to it, but you didn't give us a deadline. Give them a deadline. All right. Another thing to keep in mind is the remedy that you're seeking appropriate? All right, think about this for a minute. If you have a tenant that wasn't approved and the tenant is living in the unit, I'm just giving this as an example. Before you demand that the tenant be removed, demand that they complete the application. All right, because you're going to have to go through that anyhow. And what I mean by that is, if for some reason, I'm not saying you would do this, if this something like this got to court and you said, well, they never filled out the application, we demanded they move and they never moved. First thing the judge is going to ask the attorney is, did you ask them to submit the application? And if the answer is no, the judge isn't going to be very happy. So think about the remedy that you're asking, make sure it's appropriate before you just sort of automatically send the demand to have somebody removed. Is your remedy allowed? Okay, again, you want to check your governing documents. Maybe you want to file a lawsuit, but in order to file a lawsuit requires membership approval. That might be in your condominium documents. And a homeowner association documents, generally, and there's generally the statutes, I should say, any lawsuit over $100,000 has to be approved by the membership. There are exceptions to that, so you be aware of that, but just be aware, make sure your remedy is allowed before you automatically send a letter. I will tell you, and Lilliana, jump in on this with what you think. All of these items that I just mentioned need to be included, that should be included in the letter. A lot of the computer automatic generated letters that I see from management companies and these automatic programs do not include this information. No. And the association sends it over to us for either a follow-up violation letter, or maybe they want to move forward in the next process of litigation. And we say, send us the letters that you've sent. And we send the letters and they don't contain half of the information that they should have. And then unfortunately, we have to tell the association, we need to send a proper violation letter, before we can move forward. So sure. Make sure you go ahead, Lilliana.
I'm sorry, I didn't mean to jump in, but I just wanted to point out one of the things that you said was the citation of the provision that they're in violation of. That's my favorite part of what you talked about now, because that forces whoever's sending out the letter to make sure that they actually have a restriction that exists. Yes. Because if you don't take that step, we have gotten violation letters from management or from boards for whatever it is that they think is a violation. And when we try to take further enforcement action, we realize there's nothing in your governing documents that actually requires this person to do this. So taking that extra step to single out the article or the provision that they're in violation of is something that is not usually in those form letters, but it's really important, not just for identifying for your purposes that it actually exists, but also for future, because arbitrations and lawsuits, they want to see that there is something there that gave people notice of what they were in violation of.
Yep, I agree. I can't tell you how many times I've gotten an email from the association to either send a violation letter or an arbitration to have a dog removed or to have a car removed or a car towed. And we look at the documents and there's nothing that prohibits dogs, or there's nothing that gives the association the authority to tow. So that's a great point, Lilliana, and that's why we mention it. You need to make sure you have the authority to do what you think you want to do. I had mentioned that, you know, if the violation may lead to litigation later, whether that's arbitration, mediation, or even a lawsuit, there may be certain language that is required to be in that demand letter before the association can proceed to that next step. Just as an example, if this violation is going to lead to arbitration, there is specific statutory language that must be in that letter advising the violator that you're going to go to arbitration if they don't comply. And if you don't have that information in the letter and you go to arbitration and you get a smart attorney on the other side, or not even necessarily a smart attorney on the other side, a smart arbitrator, they're going to kick that back because they're going to say you didn't have the proper pre-arbitration notice. Same thing with demand for pre-suit mediation, which can now also be in a condominium. It used to be just homeowner associations. It can now also be in a condominium. You have to send out specific notices for some of these things before you can file litigation. So just be aware of that. These are things you should be discussing with your attorney to make sure that, you know, that these things are covered properly. And finally, let's talk for a minute, and I'll kick this over to you, Lilliana, to start it off. Let's talk for a minute about selective enforcement and waiver in regard to violations.
Selective enforcement. So maybe we should define it just to make sure that everyone knows what we're talking about. Selective enforcement comes up when, let's say, you have someone who, what's a violation? Let's do the pets, because that's a good one. There's a no pet policy in the building, and there are 15 units that have dogs, and you only choose one of those units to enforce the no pet policy against. What ends up happening is you are selecting who you are enforcing your governing documents against, and that's something that in the law can't be done. You need to enforce evenly. So if you are enforcing a violation, let's say that you're looking at the basketball hoop that got left outside, and you've got a rule that it's got to be brought in every night. If you've got 10 homes that are leaving their basketball hoops, and you're only sending a letter to one, if this thing proceeds into litigation, the one owner that's being pursued about this can turn back and say, this is selective enforcement. You're only picking on me. In fact, there's other violations that exist, so you can't enforce against me only. And they would definitely have a point. So it is really important that when you are enforcing a violation, you take the time to make sure that there are no other similar violations and that you are evenly applying your rules and regulations or restrictions against all parties who are in similar violations.
Let me ask you a question. What happens if they want to send a violation for somebody that has a dog,
I knew you were going to ask that.
which is not allowed, but they have not sent violations to people who have cats, which are also not allowed? Can that be selective enforcement?
It's an argument that is raised for sure, because they also have pets and it's a no pet policy, but there are cases that talk about there's a difference. Cats are not dogs. So it's an argument that can be made, but it's not the same violation. So it's not exactly the same. So when people are defending with selective enforcement, you do have to have similar violations for it to be selective enforcement. Having said that, enforce evenly across the board. If there's a no pet policy, don't take the chance that maybe some arbitration someday said X about cats and dogs. Enforce across the board so that you don't have problems with this. And also, particularly with pets, and we're leaving out all the talk about the pet talk that won't be mentioned here, but just for the regular no pet buildings, enforce evenly, because people purchased a unit or rented a unit in a building that has a no pet policy. These policies should be enforced across the board to everyone. So there are differences in the violations, and sometimes an association can defend against the defense of selective enforcement by saying, no, what you're pointing out are different kinds of violations. We've enforced against everyone that has your type of violation. But you don't want to get into a situation then where you are waiving, and I'll throw this one back at you, a particular rule or restriction because you're not enforcing that particular rule or restriction.
Yeah, I'll talk about
how can that come up?
Yeah, I'll talk about waiver in a minute, but I think one of the most important things to take away from this session in general is to enforce your governing documents uniformly. All right. You have to enforce them uniformly. And what I mean by that is, you know, when you send a letter to Mrs. Smith because her grandchildren were using noodles in the pool and noodles aren't allowed in the pool, and the president's grandchildren are there the next weekend using noodles in the pool, you need to send a violation to the president as well for that same violation. You need to enforce uniformly. And that's a big takeaway, I think, from today's seminar. Lilliana mentioned waiver. There's a defense called waiver. So what does that mean? Well, just like we're talking with selective enforcement, let's say you send a violation letter to Mrs. Smith, and I'm sorry for picking on Mrs. Smith. I hope there's no Mrs. Smith's listening or Mr. Smith's listening today. You need to send you send a violation letter to Mrs. Smith because she has a dog. But the board is well aware that there are 20 other dogs in the building that they've never sent violation letters to, all right? Well, the argument is, and it's a defense, that the association has waived its ability to enforce against Mrs. Smith because it didn't enforce against the other 20 owners they're aware of that are violating that particular provision. So if an association does not enforce a particular provision, there is an argument, and a good one, depending on the circumstances, that it has waived its ability to do so. Now, I'll tell you a little secret, and I'll give you a little hook for later if we have time. There's a way to get around that. And we'll talk about that later.
For my pencil.
Well, you will talk about that later, or you can contact your association for a way to get around waiver. And I'll leave that little radio station hook on there. All right, so we sent the violation letter, and either as part of the violation letter, or if they don't want to, if they end up not complying with the violation letter, one of everybody's favorite topics, and again, a topic that a lot of associations just can't seem to get right from a technical point of view for one point or another, not for a lack of trying, that's for sure, is fining and suspensions. And I know most of the time we talk about fines. Suspensions of use of common areas is also sort of part of this, but in my experience, it's not used as much as associations like to use fining. Doesn't mean it can't be. So I'll kick that back to you, Lilliana, to start that off, and we'll see where it goes.
Fining and suspension is one of the most difficult things for associations to get right, mainly because the legislature, frankly, hasn't made it really simple. The process is cumbersome, and you really can get tangled up in the details of it. So one of the letters that we get often, you can correct me if I'm wrong, but I get these letters often, Howard, is the letter from the management company or the board, official that sends out the violation letters saying you have been fined $100, pay within 5 days, and then they want us to enforce this. And of course, we ask, well, did the fining committee meet? Fining committee? Did the board levy the fine? Well, they're in violation and we have a schedule of fines. Well, that's good to have a schedule of fines, and we'll talk about that in a second. But the problem with fining and with suspension is, while they can be effective tools and they can be far less expensive than litigation, if they are done improperly, they can lead to pretty unenforceable remedies for the association. So we want to make sure that we do it correctly from the first. First is there's a several step process. The first process is the board is the party that levies the fine. So it must be a board decision at a properly noticed board meeting that determines we are going to levy this fine for this violation. That happens before a hearing happens. So if you have the situation of, let's take a bicycle that's left out in the hallway, and you've got rules that say there shall be no personal property or obstructions in the common elements or the common areas of the association. A person leaves his or her bicycle out in the hallway, and the manager sends out a violation notice, does all the right things, and says, you've left your bicycle out in the hallway 3 times this week, we need for you to bring it in. And the person continues to leave it outside. This gets put on the board meeting notice. And at the board meeting, the board looks at the situation and says, yep, we're going to levy a $50 per day fine of this violation because this person has left this bike outside in the hall now for 5 days. So we are levying a $50 fine for 5 days, and that's our decision. Okay. That board decision to levy the fine is perfectly well and good. It should be kept in the minutes, but it's actually not enforceable until the fining committee meeting happens, the fining committee hearing happens. So what the board needs to have first and foremost is an appointment of a fining committee. A fining committee needs to be at least 3 unit owners. They can't be board members or related to board members, and they need to be separate completely from the board so that they can make their own independent determination. So at least 3 owners need to form this committee. And what this committee does is very simple. They take the board's decision and they either approve or reject the board's decision. That's it. So they can't modify. Let's say they look at this fine and they say, oh, we think we agree that this bike has been left out. We've seen the video footage and we see that the bike has been left out there for 5 days. We know that the manager previously asked the owner to bring the bike in. He didn't do that. So we see that there's a violation. We agree with the board that there should have been a fine, but we think $50 a day is too hefty. We'd like to modify that to $25 a day. That's not something that the board, that the committee can do. The board makes the fine and the committee approves or rejects the fine. So either they approve the $50 for 5 days or they reject it altogether. Okay. When this hearing happens is very important because it's not willy-nilly and it's not in the cloak of darkness either. It must be a properly noticed committee meeting. And what that means is once the board makes its decision and it goes to the committee, then a notice needs to be sent out to the violator 14 days in advance of the committee's hearing. Okay, so with at least 14 days notice, the committee then has its hearing and the violator can come. He can bring his own witnesses. He can bring his own arguments, whatever it is that he wants to use to debate. Maybe it wasn't his bike. Maybe it was the neighbor across the street, across the hall's bike, and they're leaving it in front of their unit. It's not their bike and they've got evidence of some sort to show this. Whatever it is that they want to argue against the violation and the fine, they can bring that up at the hearing, and the committee will then listen to the owner or the violator and the association's evidence as well. They'll take those things into account, and like I said, they'll then have the option to either approve or reject what the board did. The committee meetings and hearings don't have legal rules and regulations that are set out by the legislature for committees to follow. This is somewhere that I strongly urge communities to meet with their association attorneys so that they can develop a plan on what the committee is going to do, what the requirements are. For example, you could have a requirement that if a violator is going to bring an attorney to the committee hearing, that the committee be notified 24 hours in advance so that the association can have its attorney there as well. There's rules and regulations.
Lilliana, are you telling me an owner can bring an attorney to a violation hearing?
Sure, they can. They sure
Wow.
can. Yeah. Well, you know, everyone has right to representation, you know, in the criminal justice system and in the association system. But, you know, if they're going to do that, it wouldn't be fair. You've got 3 volunteer committee members who are just there trying to do their service for their community to then be faced with an attorney without any notice. That can be very intimidating for them. So we routinely set up rules where notice must be given to give the association the opportunity to bring its own attorney. And it's not going to be a big courtroom brawl, but it just puts everyone at ease that there's, you know, regulations that are being followed for the comfort of all that are involved, the people who are going before the committee members, and the association, so that everyone's on even grounds. So you've got the notice, you've got the committee has the hearing, they can enact their own rules and regulations on how the proceedings will happen. And at that meeting, let's say that they decide, we approve the violation, we approve the fine. At that point, then a notice is sent out to the unit owner and the violator, the tenant, whatever the case may be, letting them know the fine has been approved and you must pay the fine. I think it's still within 5 days. Is that right, Howard?
Yes, yes, yes.
So short time frame. But I want to rewind because the same process can be used for suspension of use rights. Okay. Suspension of use rights is a rarely utilized tool. In my experience, can be often much more effective than fining. Here's why. In a condominium setting, you can fine up to $100 per day, no more than $1,000. Right? Same is true for homeowners associations, unless the governing documents for the homeowners association allow higher levels of fines. Okay. At the end of the day, all you really have is a charge, and it's not going to automatically, you can't just deduct that fine from the owner's account. You can't, in a condominium association, you can't lien for that. So if you wanted to enforce the fine, at some point, you're going to have to take that to court, which can get expensive and is extra cumbersome as well. Suspension of use rights is an offering that the legislature has set out for both condominiums and for homeowners associations. Suspension of use rights will allow the suspension of amenities. So you cannot, for example, prevent people from parking in their parking space. You can't prevent them from having ingress and egress to their unit or to their parking, and you can't shut off their water and you can't shut off their utilities. So we're not talking about things like that. But if you have a fob system, for example, that allows owners to get in and out of the pool or the gym, and they just use their little fob to come in and out of those amenities, that properly suspended person can be locked out of the gym, and they can be locked out of the pool. And oftentimes, particularly when you have a tenant in the unit, I find that unit owners pay attention a lot quicker when their tenants start complaining that they can't get to the beach, that they can't get to the gym, that they can't use the pool. All of these things become quickly very inconvenient, and it can promote a faster action than a letter saying you owe the association $700. Someday we'll collect this against you. That seems to motivate people a little bit quicker, at least in my perspective. And I don't think it's utilized enough, but it would go through the same process. You still have the board making a decision about a reasonable suspension. Okay, how long it's going to be suspended for, and what amenities or what it is that is going to be suspended, what use rights are going to be suspended. And after that, then you still have to give the issue over to the committee, which again has to go through the notice procedures. So you have to give the 14 days notice mailed to the unit owner, the violator. They need to have a hearing where everyone can come and speak their piece. And after that, then the committee will approve or reject whatever the suspension was that was before them.
Lillian, let me ask you, we've got a number of questions, good questions that have come in on the chat regarding the committee, the finding process, all that kind of thing.
Yep.
So I got a couple of my own.
I'm glad you're monitoring those.
Yeah, and then I'll go to some of yours. So the statute says, or you said that the committee has to be a committee of three, at least three. And let's say it's three. Do all three have to be present for the committee meeting to take place?
That's a really good question, actually. No, if you have a committee of three, then you have a quorum, which is a majority of the committee. So you can have two people. That's your meeting. The same as if you had a board meeting, you have three members of the board, two people form the quorum because it's a majority. And then in that case, you would have to have a unanimous vote if there's just the two of them.
All right. And are these committee meetings open to the membership?
Oh, that question. It is often debated. In my opinion, they are open to the membership.
I agree.
I don't see how you can close this. This is, I mean, the board meeting at which the original violation is referenced and the suspension or the fine is issued is obviously open. The committee meetings as well. I just don't see any provision under the law that would allow anyone to close this. So I do think that these are open meetings. It's an uncomfortable thing to do.
Yeah, no, I agree. And does that mean, I guess it would mean then that these committee meetings need to be noticed just like a board meeting?
I mean, yeah, I think so too. To the owners and the violators, they need the special 14-day prior notice. But it would be, I think, in order to be able to have owners attend, a 48-hour notice like a board meeting, an ordinary board meeting would suffice.
Mm-hmm. Here's an interesting question. Can a fine committee meet?
I don't like that giggle.
Can a fine committee meet before the board of directors about a violation?
Can it meet? Well, I
I
don't know
mean,
what it would be meeting about because
I
it
guess
doesn't
they
have
can
the
meet,
issue.
but I guess they can't impose any fine.
I mean, yeah, I don't even know how they would know about the
Yeah,
issue because it normally doesn't come to the committee until the board itself has made the determination that a fine or a suspension will be levied. Remembering always, this is really the board's approval. The committee is just approving or rejecting what the board decided. So the committee can't do this on its own. And
right.
I don't see how it would get to the committee prior to the board saying, yes, there will be a fine or suspension here.
Couple more questions and then we'll move on. When discussing the to be imposed fines at the board meeting, should the board discuss it by the person's name, by the unit? Are there any privacy concerns? What's your take on that?
I mean, the privacy concerns usually come in when we're talking about people owing money, and that's not something that you would levy a fine for, which, by the way, we should clarify. You don't fine somebody because they haven't paid their assessments. There are separate procedures for that. You fine someone or you suspend, well, suspension is different, but you fine someone because there's a violation of the governing documents. As a result, I don't think that there are privacy rights to the fining discussion. All of the complaints, the incident reports, all of those are official records of the association. Unless they fall within one of the categories that would exempt an owner from reviewing the official records of the association. So unless it has to do with medical records or personnel records or attorney-client privilege or any one of the numerous exceptions, they're just official records of the association, and presumably anyone can peruse the incident reports for such and such unit because they're part of the official records of the association. So I don't think there's any privacy attached. That being said, I typically do have board members deal with it by reference to a code saying, unit issue 1, issue 2, issue 3
Right.
before the board. Suppose if someone asked a question at that point, then we could expand.
Yeah, I agree. Last question on this, and just a general, I guess, statement to confirm. All of these processes we're talking about generally apply to condominiums, cooperatives, and homeowner associations equally, correct?
Yes. The only big difference between the HOA and the others is that in homeowners associations, your governing documents can allow you, and this would be your declaration, can allow you to impose fines of greater than $100 per violation or $1,000 maximum. So that's one thing that is different. And also in a homeowners association, if there's a fine that's over $1,000, that can result in a lien against the property, wherein the other two would not ever result in a lien against the property.
Okay. Well, listen, I'm sure we could spend another 2 hours talking about just this aspect of the covenant enforcement. And we have a lot of questions and we'll try to save some time at the end to get to some of them, but let's move on, try to get through some more material. So you've issued the violation letter or letters, maybe you've imposed a fine, whatever the case may be, and the owner still, or the tenant still refuses to comply and the association wants to take the next steps. So let's talk about those next steps, what those next steps are, or how we transition from the violation letter to litigation. And the statutes were changed a couple of years ago. Before, condominiums and cooperatives basically had a pre-arbitration demand before an association could file a lawsuit for some violations that we'll specify in a minute. But the homeowner association statute was a little different, and it had what was called a demand for pre-suit mediation. The statutes were changed a year or two ago to where in a condominium and a co-op, the association now has the choice to either do a demand for pre-suit mediation or a petition for arbitration. So whether or not to go to arbitration or mediation is something you should discuss with your attorney. Obviously, there are pros and cons to both. I think it depends on the violation. I think it depends on the association situation. And again, we could spend another 2 hours talking just about that. Excuse me, but I just want everybody on the webinar to be aware of, in a condominium association, you can now do a demand for pre-suit mediation as well. And there is specific language that must be included in a letter to an owner when you're demanding they attend pre-suit mediation. And you have to send this letter and they have to respond within 20 days. If the other side does not respond within 20 days, or conversely, if an owner sends a demand for pre-suit mediation to the association, demanding the association mediate an issue, whether it's condominium, cooperative, or homeowner association, the association has 20 days to respond to that demand for mediation, agreeing to mediation and selecting one of the offered mediators. What happens if either side doesn't respond within 20 days? Well, the hammer is, if you don't agree to mediate within 20 days and a lawsuit is filed and you win, you're not entitled to your prevailing party attorney's fees because you refuse to participate in pre-suit mediation. So again, the takeaway from this is, in my opinion, whenever the association receives a demand for pre-suit mediation, I can't think of a circumstance where the association would not want to agree to participate in the mediation to protect its rights to get prevailing party attorney's fees. Would you agree with that, Lilliana?
100%. And I was actually going to jump in to just throw my support behind mediation. I think it's a tool that people think won't work because we've tried to talk to this person and they don't behave, they don't do what they're supposed to do, and they won't fall in line, or they won't follow the rules. Mediators are specifically trained to help people see the error of their ways on both sides. And it can be a very valuable process. It's not always going to help, but I think mediation is definitely something that is overlooked and shouldn't be, because it is the definition, alternative dispute resolution. It is an alternative to going to a third party who is going to make a judgment without either of your participations, where at least in a mediation, both parties are coming to an agreement. And if you come out with a solution that neither party is happy with, then it's a good settlement. But at least you are avoiding the expenses that are associated with litigation, which can, get big. And you are also trying to come to a situation where you can be assured of future, not assured, but you have a higher percentage of future compliance because the owner and the association were both part of the process and both came to an agreement on how to resolve it in the future. So
I agree with that. And also, just from a timing perspective, if you agree to go to mediation, the mediation has to occur within 90 days. Typically, it'll occur within 30 to 45 days. And if you come to an agreement, great, 30 to 45 days, boom, you're done, case over. If you file a petition for arbitration, which again, may be required in certain circumstances, or the association may want to do so for other reasons, but in a petition for arbitration, you're looking at a minimum, in my experience, 2 to 3 to 4 months before there's a resolution, if you're lucky, before you can get an order from the arbitrator. So I agree, there's nothing wrong with going to mediation. And if you have a written mediation agreement, and then either side doesn't comply with that agreement, you can go to court to enforce that agreement. That is a fairly simple court case. It's not a complicated, lengthy court case. It's a fairly simple court case to enforce the mediation agreement. So I agree with Lilliana's take on that. Let's talk about the arbitration process, which has had its ups and downs over the years. But nonetheless, Lilliana, you want to start on that, and then maybe I'll jump in.
I'd love for you to jump in because you as the litigator do most of these arbitrations, whereas I just say, this is something that needs to go to arbitration, but we can talk about it. The thing with arbitrations is it is a process that was intentionally made easy for unit owners to participate in. So it is not it's not going to court before a judge. It is petitioning for arbitration before an arbitrator. The main difference between a judge in, Dade County, Broward County, Palm Beach County, whatever county court is, these arbitrators, this is all they do. For better or for worse, this is what they do. So they really have heard a lot of condominium disputes. Whereas if you once you get to the circuit courts, which is just the regular courts, at this point, these judges have heard every kind of dispute. Condominium is just one of them. And a lot of judges, they just kind of, oh, I don't know this law because it's so nuanced and very detailed. And so they can get tripped up on things that arbitrators have just seen more of. So for better or for worse, arbitrators, they do have a lot of experience. We don't always agree with the way that they come down on things, but they have seen a lot of things and they are experienced and they can understand what's going on maybe a little bit quicker. So what are the kinds of things that are eligible for arbitration? So what can go before an arbitrator is an issue that questions the authority of the board of directors to require an owner to take action or not to take action involving that owner's unit or limited common elements pertinent thereto. So if they maybe have to maintain something in their unit that they haven't maintained and the documents require them to take such action and they haven't done so, then that's something that can go before arbitration. Also, the board of directors right to alter or amend, or excuse me, alter or add to a common element or a common area. So you'll see a lot of material alteration issues that can come up in arbitration. Also, the failure of the board of directors to properly conduct elections. So you see election disputes in arbitration. Notice of meetings, if they haven't given adequate notice of meetings to properly conduct meetings, they're not proceeding with quorum or they're not getting the votes that they need to get for a particular issue, and official records disputes. That's one that comes up quite a bit in arbitration, usually from the unit owner's perspective. A unit owner doesn't get access to the official records that they think they can. And so they file a petition for arbitration to get that access and the arbitrator can deal with that. Also,
I'm sorry for interrupting, Lila. Let me jump in about the inspection of records because some associations may have a question. Well, we got a letter from the division that we were in violation for a record inspection. Don't they have to go to arbitration first? The answer is no. A unit owner can go to arbitration if they want. And in my personal opinion, I think the only reason they do that is to give more of a hammer to the association and try to get paid for their attorney's fees that they don't have to incur in the first place. Because all an owner really has to do is file a complaint with the division, and the division will investigate that complaint, and the division will make a ruling as to whether, in its opinion, the the association violated the records request procedures or not, and the division can issue the fine or the penalty payable to the owner. So I don't want, yeah, and they do all the time. So I don't want anybody watching the webinar to get confused as well. We got a letter from the division or they filed a petition for arbitration. They can do either. The letter with a complaint with the division is the quicker, simpler process. But if an owner really wants to stick it to an association, or conversely, if an association has really been sticking it to the owner about legitimate records requests, the owner may want to file an arbitration action to stick it back, so to speak.
Yeah, and I think also what you get, and we should clarify, they're both the division, right?
Correct.
Correct. Yeah, I mean, just because it
different
might
sections.
Yeah, different sections, right? So I think one of the things that an owner can get in an arbitration that it won't really get in a complaint is the arbitrators can just explain in an opinion, in their findings. They talk more than just saying, yes, you're in violation, or no, you're not in violation. So they get something that's waivable, I guess, that says, yes, the association did X, Y, Z, and they'll lay out the facts. And it's more like a trial than it is just a complaint and a finding. A couple things that arbitration does not include. I just noticed the time and I can't believe we've gone through this hour.
I know.
It's a thick topic, but I just want to clarify some things that you cannot bring to arbitration. Anything that has to do with a title to a unit or a common element. That's my parking space. That's not my parking space type thing. The interpretation of or enforcement of any kind of warranty. This is usually in new construction. So that's not something you'd normally see. The levy of a fee or of an assessment. So again, you wouldn't go against an owner for failure to pay, some assessment or something. You wouldn't do that in arbitration. Eviction, if please talk to your association attorneys before you threaten eviction against any tenant. I don't care what your documents say, talk to your association attorney. But if you have the right to evict, it's not something that you would be doing through arbitration. Breaches of fiduciary duty by any directors. If a unit owner wants to seek breach of fiduciary duty causes of action, not something that would be doing through arbitration. And finally, any claim for damages to a unit based on the association's alleged failure to have maintained the common elements. Those kinds of things are not going to go before arbitration. The unit owner can try, they'll probably get kicked back by the arbitrator saying this is not something that we see.
If you want, Lillian, I'll go over the briefly review the arbitration process. So let's say, for example, the association consults with their attorney. They want to go through the arbitration process. So the association will file a petition for arbitration, and there's a form that's used. I don't want to say there's a form that's used. There's a format that the division requires to be used, where you will lay out the association's arguments, what was violated. You have to submit proof of the pre-arbitration letter. If you remember, we talked about that under violation letters, and that pre-arbitration letter has to state specifically, if they don't comply, that they're going to go to the association is going to go to arbitration. If you don't have that magic language in the letter, 98 times out of 100, the arbitration will get kicked back for failure to comply with the condition precedent, and you will have to send that letter before you can refile the arbitration process, the petition for arbitration. You have to include the exhibits with your petition, a copy of the association documents, whatever violation letters were sent, whatever other exhibits you may have to present the case. Once the division receives that petition, it's assigned to an arbitrator. The arbitrator will make pretty much a cursory review and decide whether the arbitration section has jurisdiction based on some of the things Lilliana says they don't have jurisdiction over. And if the arbitrator decides the association, or that it does have jurisdiction, it will then issue an order requiring answer to what's called the respondent. In a lawsuit, it's the plaintiff and the defendant. In a petition for arbitration, it's the petitioner and the respondent. So the arbitrator will issue an order requiring answer to the respondent, which is typically the unit owner. They send that letter to the owner via certified mail. If for whatever reason that letter is not signed for, or the division can't prove that the order requiring answer was received by the respondent, they can and will require the association to serve that owner, just like you serve a lawsuit, okay? Because they want to make sure the owner gets served with that before things proceed. The owner typically has 20 days to file a response, just like an answer and affirmative defenses in a lawsuit. They have a right to do that. And then the arbitrator will look at that. And I would say in most cases at that point, the arbitrator generally will schedule a case management conference, which is nothing more than a telephone conference with both sides, where the arbitrator sort of goes over both sides' position, wants to see if they can agree on any issues, see if they can narrow the issues. And then there are two ways for a petition for arbitration to be finalized, for lack of a better term. Either A, the arbitrator will issue what's called a final order based purely on the pleadings, meaning the arbitrator look over everything that's been submitted. At that case management conference, the arbitrator may say, please submit a proposed findings of facts and proposed order or memorandum of law in support of your position. The arbitrator will look over all that. They will issue a final order. That final order will be for one side or the other, either for the association or against the association. And whatever that order says, you're required to comply with. There is, for lack of a better term, an appeal process. And what that means is that either side can appeal the arbitration order. I don't like that term, but that's the term everybody understands. By filing what's called for a trial de novo. Basically what that means is the losing party can say, you know what, we don't agree with you, arbitrator, we're not going to file this in court. And they have a right to then file a lawsuit. That lawsuit in court is from scratch, completely new. You have to present and prove your case all over again. You can enter the final order that the division arbitrator entered, whichever side wants to enter it. I will tell you, without going into any details, based on some case law over the last few years, those arbitrator orders have much less weight than they used to. All right, so just keep in mind, just because you won an arbitration has unfortunately nothing to do with this trial de novo process.
Well, it's right in the name, trial de novo. The court's going to be looking at it brand new. Novo
Exactly.
being a completely new look, and whatever the arbitrator found is just something else as part of the case.
Correct. The prevailing party in arbitration is entitled to prevailing party attorney's fees. The prevailing party attorney's fees, a motion has to be filed for that within 45 days after the final order. It's a little different than court. It's generally 30 days after a final judgment, but in arbitration, it's 45 days. And I think they did that so you can allow the 30 days that you have to file de novo to pass before you file your motion for attorney's fees and costs in an arbitration matter. If it goes to a trial de novo, and obviously in any court case, well, not in any court case, because this is based on the declaration, the contract, or statutes, the prevailing party in the trial de novo is entitled to prevailing party attorney's fees, and that does include the fees incurred at arbitration. All right, so this can be, a little bit of a lengthy process. If you're going to get, or if you're going after fees awarded in a petition for arbitration, just be aware that generally arbitrators probably only award 60 to 65% of the claimed fees that the association will claim in an arbitration matter. There's a lot of reasons for that. I was just at a seminar this weekend discussing those issues with the head arbitrator. And basically the reasoning is arbitration processes for the owners. It's supposed to make it a little bit less expensive. They try to, just because an attorney in Miami might get $350 an hour, an attorney in Tallahassee might get $200 an hour. So they try to even it out over the state. Doesn't matter. Just be aware in our locale, if you're going after attorney's fees and costs for a petition for arbitration, you're probably only going to get 60 to 65% of the fees claimed.
And it can get expensive because the process can be lengthy.
Yeah, and one last thing I forgot to mention. I said the first option is a final order that the arbitrator can issue based on the pleadings. The second option is a final hearing, where there is actually a hearing in front of the arbitrator, and it's a mini trial. It is a mini trial. Both sides put on their case. The arbitrator typically attends by phone. So both sides will be in an association area, in a conference room, set up like a courtroom with instead of a judge up in front of you, you have a telephone with the arbitrator on the other end. Call your witnesses, you give testimony, you enter evidence, just like a regular trial. And I would say generally these go anywhere from 4 to 8 hours. Sometimes you might have a 2-day final hearing. And Lilliana mentioned it can get expensive. That's when arbitrations get expensive, because that's just like a mini trial. The attorney has to prepare just like a trial. And I have seen arbitration costs with a 1 or 2 day final hearing, $25,000, $30,000. And again, keeping in mind that the arbitrator, if the association prevails, is only going to award 60 to 65%. So for argument's sake, if it's $30,000, the association is probably only going to get back about 20. And unfortunately,
which is why I reiterate my, sorry?
No, go ahead.
No, which is why I reiterate my cheerleading for mediation. If it's something that can possibly be mediated, and that's an option to resolve the problem, not only for time efficiency, but also for money. It can be a cost-effective and time-effective, efficient resolution if you've got people on the other side that can be reasoned with.
Exactly, I agree. All right, so I'll try to wrap this up in about 5 minutes. So if there's a trial de novo, that's just a lawsuit. We don't have time to go into what's involved with the lawsuit, today, but I'm sure everybody sort of has a general idea what's involved in a lawsuit. But I do want to talk about a couple other things that are important in regard to these types of complaints if they're filed against the association. If an owner files a demand for pre-suit mediation against the association, or more importantly, if an owner files a petition for arbitration against the association, should the association report that to its insurance carrier? And what do you think, Lilliana?
I'm sorry, repeat that?
If an owner files a petition for arbitration against the association, should
Sure.
the association report that to its insurance carrier?
Sure,
Yeah,
sure,
I
absolutely.
agree. And a couple of reasons are, an association may say, well, maybe we'll get, a final order, maybe you can handle it for us, which we can.
Yep.
Maybe it only costs $5,000 or $6,000 or $7,000. We got a $5,000 deductible and we don't want to,
Right.
add to our premium increase. But if that ends up going to a trial de novo, and then you notify the insurance company later, they're liable to
Right.
say there may be an exclusion in their policy for lack of proper notice, and
Yep.
they're not going to cover the lawsuit. And so now all of a sudden the association is on the hook for all those defense costs instead of your insurance company. So I would always report a petition for arbitration to your insurance company. And then, if they want to say, hey, let the association attorney handle it or whatever, that's fine. If they assign defense counsel, which they generally will, I would always recommend that the association engage a CA litigation attorney to monitor and work with the insurance counsel in defending that petition for arbitration.
Yep.
Because while insurance counsel are generally very competent attorneys, sometimes they don't have the CA, the community association experience and nuances in regard to the law and the arbitration process that a community association litigation attorney would have.
Yeah, and it's something to note that you should talk to your insurance company, your insurance agent, when and if you do report it, because different policies do allow you, can allow you to appoint your own CA attorneys. And like Howard was saying, it's not just that they know CA process specifically, but they know your community because it's your attorney. They know they've probably been the ones that have been sending out the demand letters and have been along the way for the entire process. So
Right.
if that's a possibility with your insurance company, it's something that you should definitely explore, which would mean that rather than the association paying for the CA attorney to defend the association, the insurance company would be making those payments, but you'd still get your own attorney. So,
yep. All right, Lilliana, do you have any wrap up words? And then I'll add a couple and we'll let everybody go have their lunch.
I wish that we could answer my wrap up words. I wish we could answer all these really good questions that have been logged in the chat. The process for enforcing your violations is cumbersome, but it is important that you cross every T, dot every I, do everything correct from the beginning, beginning with identifying that there is in fact a provision in your documents, with the correct notice be sent out to give them warning and let them know they're in violation. If you're going to be doing fining or suspension, to properly follow every step, touch base with your association attorneys along the way, and make every effort to try to resolve this without getting to this last topic that we were talking about, which is putting it in someone else's hands, a third party fact finder's hands, because at that time, it really is something that's out of your control. And remembering always that fining is not a revenue generator for the association. That's not the point of this, right? What we want to send letters for is to curb violations. Enforcement of covenants is so that we have a community that lives with the agreements that they agreed to live by when they first moved in. So the purpose really is getting people to comply. You want to stay away from just fining for everything rather than trying to get compliance, because at the end of the day, what you really want is a happy community. You don't want to just be fining people, because that's not really necessarily going to stop the violations.
What she said, plus, I gave you a tease earlier about a way to get around waiver, and I'll just tell you what it is, and you're going to want to discuss it with your association attorney. But if an association hasn't enforced rules for a while and the board decides they want to begin enforcing that rule, ask your attorney about a chattel shipping letter, CHATTELL shipping. That's the name of a case, but it's referred to as a chattel shipping letter, and that is a way to get around waiver, and you can start enforcing those provisions moving forward. I'll leave you with
I've got one more thing.
Yes,
I've got one more thing. In line with the chattel shipping, one thing that you should do is periodically send out a copy of your rules and regulations to your owners and to your residents, because many times you have violations because people don't know what they're supposed to be following. So it's really important to make sure that everyone knows that there are rules and regulations. You'd be surprised the amount of people that honestly did not know that there was a restriction regarding X. So periodically, once a year, however often you'd like, but something with some regular frequency, send out your rules and regulations and your restrictions, your association governing documents. Nowadays, if you have a website, publish it on your website because you have to, or even if you're not under a requirement to do so, publish it on your website. Remind people we live under these restrictions. Remind them to read them, because you'd be surprised how much compliance you get when people realize that there's a rule regarding X, Y, or Z.
Yep. And my parting thought is, your association attorney can never tell you what the outcome of a mediation, an arbitration, or a lawsuit will be. They can never tell you what the outcome will be. They may be able to advise the association that in their opinion, the association has a good case, or the association has a 50-50 case, or the association has a bad case. But I can tell you from experience, and I know Lilliana can as well, many good cases have been lost and many bad cases have been won. So keep that in mind as you go through your process. I want to thank you all for attending. I'm sorry we went over a little bit late. This will be available for you on the webinar. So everybody have a great day. Thank you.
Bye. Thank you.